Here we are, protecting your assets and knowing the options. Now, first and foremost, we are here to talk about asset protection. Asset protection can be your home, can be your bank accounts, your investment accounts. But the way we do things is while we're protecting all of those, we're also focusing on our clients. One of the biggest assets that we help families protect on a daily basis is their home. And we're here to also protect who lives inside that home. The way we do things is like every elder law firm in that we'll focus on the assets, we'll focus on the protection, we'll focus on the Medicaid work when we're dealing with care issues. But we also focus tremendously on those care issues. We do practice a little bit differently in that the care, the advocacy, the welfare of our clients, and making sure they're getting the best care are paramount while we're helping our families. So it's not just, as I say, about the documents and the dollars. It's also about the care that our clients are receiving if they're in that type of a situation, okay? So what are the risks? What are we protecting against? Well, there's three things I'm going to be talking about today. There are more, of course. I'm not talking about taxes today per se. I've done, by the way, if you go to our website, tullyelderlaw.com, again, I've been doing these webinars for a year and a half. If you go under the video tab and click on webinars, you'll see a whole slew of webinars with a lot more depth on specific individual topics that I'll be talking about today. For example, I'm not really talking about taxes, but a couple of months ago, I did an estate tax webinar. So you can go down to the website and find out if you want a little more depth. But what we are covering is going to be the idea of long-term care, right? Surprise. That is something we touch upon almost weekly because it is a significant risk and it can be dealt with without a crisis. So part of these webinars is the purpose is really to say, listen, get the planning done, get the protection done before the crisis arises. But we'll talk about why it's a risk and how it's a risk and what can be done. We're also going to be talking about something called guardianship. Not something we talk about a lot here in our webinars, but it is something that we face not on a daily basis, but weekly or monthly. And again, I'll explain what it is and how we can work on minimizing that risk or avoiding it altogether. And finally, we'll be talking about the risk of probate. Probate, and again, I'll explain it, but it's not just dealing with the courts when people pass away. If there's a care need out there, and if we're looking at that Medicaid program to pay, they can come in and take the house. They can come in and put a lien on the house. So there's significant risks with probate, more than just the typical, hey, let's avoid probate if we can, okay? And again, I'll get into that a little bit today. So one at a time. Focusing on long-term care first. What exactly is long-term care? Well, as I share quite often, long-term care is one of the things, one of the issues that can arise as at any age, but typically as we're getting older. There can be medical needs that we face, or there can be long-term care needs that we face. The medical needs are going to be those that where we see our doctors and and go to hospitals and rehabilitation centers. Those medical needs are the ones where our health insurance or Medicare is paying for it, okay? On a side note, a little commercial for next week's webinar. Next Wednesday, we have Doreen Marino joining us. She is a Medicare specialist, and she'll be talking about Medicare open enrollment, the supplemental plans, the Advantage plans, and so forth. But Medicare is just medical. What we're talking about here is long-term care. What is long-term care? Well, it is the activities of daily living primarily, meaning it's your functional abilities. What can you do? What can't you do in your everyday life? And to just give you a short list, it's really what we do every morning, right? You got out of bed. It's called transferring. You walked to the bathroom. You used the bathroom. You bathed. You groomed. You dressed. And ultimately you ate. Those are the primary activities of daily living. If you're not able to undertake those on your own independently and you need assistance, well, then you're dealing with a long-term care issue or your loved one is. Now, on the other hand, it's not just the physical component. There's also the cognitive element, all right? And those are demonstrated, if you will, more so than just lack of memory or short-term memory or repetition, those of course can lead us to talk about the dementias and the cognitive decline. But the instrumental ADLs, the instrumental activities of daily living, that is also another list. Perhaps more of an obvious list, such as driving. If the ability to drive or to undertake public transportation is gone, there can be more of a cognitive decline. That can be a red flag in that regard. Preparing meals, paying your bills, shopping, house cleaning. Those are the instrumental activities of daily living. And yet, while not physical, completely physical and functional in nature, they can lead to the reality that long-term care needs are upon us, okay? So the fact is, every day of the week, every hour of the day, we're helping families deal with these long-term care needs, either preparing for them or helping them endure, helping them obtain the right benefits, helping them to protect their assets, helping them to get the best care possible, the best long-term care possible, okay? So there are two places primarily where people can receive long-term care: at home or in nursing homes. Yes, of course, there's assisted livings in the middle. There's even what are called independent livings. And yes, there are even called continuing care retirement communities, all valid places to receive long-term care. But those assisted livings, independent livings, and CCRCs, as they're called, are really private pay. So you're using your own money to pay for those. When it comes to the long-term care we're talking about today, we're going to be getting into Medicaid a little bit. So that's where the risks are. That's where we need the protection. So home care, that's primarily what people want. You want to stay home. Yes, a nursing home may become a reality if the medical needs are too great for home, or perhaps if the behavioral issues are too aggressive for the home scenario. But 100% the goal for 100% of the people we talk to is let's stay home at least for as long as we can. However, it gets costly, and long-term care has to be paid for, all right? These are the approximate costs. Home care can be anywhere from 25 to 30 bucks an hour, say. And if you have an aide come in, because that's the type of home care you can receive, a personal care aide can come in, you can be looking at $200, $300, $400 a day, $500 a day upwards. Usually caps out between $300 and $400 though. And if you add that up during the week, you add that up monthly, you could be looking at $2,000 to $10,000 a month to pay for home care. All right. So it can add up very quick. Now, I'm not saying people don't have to pay for care on their own in the beginning, because they do. The reality is that while there are benefits out there, which we'll get into, they take time to process. And people generally have to pay for the care on their own when that time comes. The reality is, I share with families, we're providing long-term care for our loved ones before it even becomes formalized care. We're helping with errands. We're helping with getting up and out of a chair. We're helping up the stairs. That's the informal aspect of long-term care before we have to hire somebody. Then when we start looking at a nursing home, my goodness, you can double the home care numbers. You're talking anywhere from $14,000 upwards of $20,000 a month for a nursing home. Astronomical. Some clients can pay that, a lot, and most can't. And even if you did have several $1 million as a net worth, $250,000 a year can certainly eat up any type of savings that perhaps are going to be needed for a surviving spouse, or savings that could be needed for a child or a disabled child, an inheritance. So there's the reality that, yeah, we can pay a little bit, but it's not something that most families can sustain in the long run, okay? So how exactly do we pay for long-term care? Well, it's very, very expensive, as we just learned. 3 ways to pay for long-term care. The first we just discussed, using your own money. Untenable for most families in the long run. The second is what's called long-term care insurance. Long-term care insurance is a separate health insurance policy that it's like life insurance. You have to have a certain level of health and you have to be able to afford it. You have to qualify. So if you can qualify for long-term care insurance, that is a private way to push that risk onto an insurance company. Yet you have to pay your annual premiums. but you're purchasing coverage for home care, assisted living care, nursing home care. So it's certainly a good way to do it and to keep you in charge of where your dollars go, and to stay away from the government. But most people do not have long-term care insurance. And quite honestly, most of those that do, the benefits are not robust enough to pay for the daily care. So as I was saying earlier, if a home care need is present and it's going to cost $350 a day, and you only have $100 a day worth of long-term care insurance coverage, you still have a $250 shortfall. And likewise with a nursing home, if you have a $700 daily cost at a nursing home, private pay, but you only have $150 or $200 long-term care insurance, there's still going to be significant need there. So again, long-term care insurance exists, but it's not always there, or it's not the answer. Now, what most of us end up doing is we turn to the Medicaid program. I said earlier, Medicare is for the medical needs. Medicaid in our world is for the long-term care needs, okay? It will pay for that home care. It will pay for that nursing home care. It can even pay for some of the assisted livings, but only a handful of them. It's what's called the ALPs. It stands for Assisted Living Program. So that's out there too. But the reality is Medicaid becomes the serious option for many, many families because they cannot sustain the multiple thousands of dollars a week that care can cost, okay? So a little bit about the Medicaid program. Again, go to our website if you want to learn more about the nitty-gritty of Medicaid eligibility and the changes that are happening. I'll talk about it briefly in a moment. Prior webinars get into that significantly. That's not what we're going to get into today too much. But Medicaid eligibility, again, they will pay for care in the house and they will pay for care in a nursing home if eligible. Eligibility is about three things. It's about the applicant's assets, it's about their income, and it's about their care level. How much care do they need? Is it a home care level or is it a nursing home level? And there's different tools and assessments that are done to gauge that. We, as an elder care law firm, help with those assessments. We are unique in that we have advocates on staff. It's what we call elder care coordinators. And they literally will be there during those Medicaid home care assessments to advocate for your loved one, to make sure that they're getting into the program and that they're getting the most hours of care possible. And also to act as resources and support for the caregivers. So the care aspect is huge. On the asset and income side, you're looking at a person's assets being either spent down, which you don't want to do, to $15,900, which is the asset maximum when it comes to Medicaid, plus retirement accounts. And again, I get into those details in other webinars. So it's how do we protect everything above that? Or how do we protect as much as possible above that $15,000 number? That's where asset protection comes in. On the income side, and income protection is a real thing too, there is a cap also for income if somebody is going to a home care scenario or a nursing home scenario. So on the income side, you're looking at $904 a month for home care. The good news is that we can usually protect most or all of the income above that $904 number. Whole different process during the Medicaid application, okay? So that's how we gain Medicaid eligibility, working with the assets, the income, and the care levels. Now, the complications when you're dealing with Medicaid eligibility really come into play with the finances and this look-back period. Now, most people have heard about the 5-year look-back period, and that applies to nursing homes. Gratefully, the 5-year look-back only applies to nursing homes. However, major changes are coming in regard to community home care Medicaid. So, and again, more webinars on the website that talk about this at tullyelderlaw.com. But the reality is that New York will eventually have a home care look-back period as well. It was signed into law last year in 2020. It's just that the implementation has been postponed due to the pandemic. So at some point in 2022, we were expecting January 1st of 22 for the look back period to commence for home care Medicaid. We are hearing rumors and rumblings that it's going to be postponed to April 1st. I think it's fair to say that due to the pandemic and different public health emergency requirements federally, that the look back period for community Medicaid is going to be postponed until April 1st of 2022, which means if you have that home care need, or you're going to, and you're heading that way, now is the time to protect. Now is the time to actually get the application going, okay? Again, we talk about that a lot more. If you have questions, put that in the chat box. I'll be happy to get into it a little bit later. So that's the Medicaid risk, because that program is going to be the payer of long-term care for most families. And because they have such strict requirements on the assets and income and these look-back periods, again, new for home care, the reality of losing significant assets is real. It can happen, and we've seen it happen, unfortunately. So you want to take the time to protect, all right, in regard to Medicaid and long-term care. The next risk that we're going to be talking about is guardianship. So guardianship it's a court proceeding, okay? Now let me share when this happens. As a part of planning for clients, we will always recommend or verify that one exists, verify a durable modified power of attorney exists. A power of attorney is where a person, a principal, can delegate, appoint an agent to help them with their legal and financial matters while they still have capacity. And that power of attorney, as I'm going to talk about in a little bit, has to be written a certain way. It has to contain certain language. And if you have that power of attorney in place, and if it has all the right language and provisions built into it, then you don't got to worry about guardianship, all right? Because that power of attorney, as long as it's done properly, is how you avoid guardianship. However, a lot of people come to us with no power of attorney in place or the wrong power of attorney in place. So if there's a loss of capacity and if there's an inability to sign a new power of attorney with all the right language, this is where you're going to end up, okay? A guardianship proceeding is an adversarial court proceeding. It's where a person who's, quote, interested, perhaps a child, even a spouse, would engage a law firm to say, my loved one, what is called the alleged incapacitated person, is in jeopardy of harming themselves financially, or they are in jeopardy of harming themselves personally, their health. So I need you, judge, to step in and literally declare my loved one incompetent based on evidence and facts, not necessarily a diagnosis, and appoint me as the guardian of the person to make healthcare decisions and guardian of the property to make all the financial decisions. It's adversarial. It is a lengthy, costly process, and it's something that can be avoided. All right, so let's put a big exclamation point on that. It can be avoided, so we should all do what we can to avoid it. One of the reasons it can get so costly is because you can have 4 attorneys involved. If you think one attorney is expensive, wait till you have 4. So there's an attorney for the petitioner. That's the one asking the court for the intervention. The court will then appoint what's called a court evaluator, usually an attorney, to go investigate, interview, and create a report and recommendations to the judge. In addition, the court may appoint a third attorney to actually represent your father, that alleged incapacitated person. And the fourth attorney might actually be a sibling that disagrees with you, which does happen. And then that becomes what's called a contested guardianship. A straightforward guardianship, still something you want to avoid, but a contested litigious guardianship, you could be talking a couple of years. You could be talking upwards of $80, $90, $100,000, all right? That's litigation. So those costs are something you truly want to avoid. The time delays, think about it. If mom needs Medicaid, mom needs care, and there's no power of attorney, and she's got $200,000 in her name, she's not getting Medicaid. We have to go through a guardianship proceeding. Well, what's going to happen with that money during the 8-10 months that we're pursuing the guardianship? We're spending that money as long as there's legal access. So it's really something that can be avoided, as I said, and really get the right power of attorney, speak to us. will make sure your family doesn't have to deal with this, okay? That's another risk. It's significant. Gratefully, I have colleagues that practice guardianship all the time. We don't, gratefully, because our job is to really help families get that planning done before this happens, okay? So it's unfortunately a reality for a lot of families, but again, it should be avoided. The next risk is the third one that I mentioned, and that's probate. Probate is also a court proceeding, and if you're not getting this on your own, let me put it out there. The courts should be avoided as much as possible, whether it's a probate proceeding or a court proceeding like guardianship. You don't want the courts intervening, the time delays, the costs, the stress, a judge who may or may not like you, or you may or may not like the law that they're going to apply to your case and your situation. You lose control, you lose privacy, you lose time, and you lose money. So the courts and the judges, good people, necessary institutions, but avoid it if you can. And that's what today's about. Now, probate is the best way to explain this. This is the court proceeding that's required if a person passes away with an asset in their name solely, okay? Meaning that your father passes owning the house. Mom's not on the deed, or mom's predeceased. Dad passes owning that house. There's going to be a probate proceeding. Mom passes away with $50,000 in the bank. No joint owner, no beneficiary. It's not in a trust. There's going to be a probate proceeding. So if it's in the person's name solely, then this is what you're going to go through. Now, how do you avoid probate? Well, 3 ways. Make sure the accounts are joint with somebody, or make sure there are beneficiaries on the accounts if allowed, or third and finally, make sure that the asset is owned by a trust. So between joint ownerships, beneficiary designations, and trusts, you can avoid this, just like the guardianship, completely avoidable, okay? So take the steps while you still can to set up that protection plan to avoid it, okay? Now, why is probate something that should be avoided, beside it being the courts? Time delays. You're looking at 6 to 8 months if everybody gets along and if everybody is locatable, all right? What I mean by that is, if you have 4 children and one hasn't been heard from in a number of years, and that happens more than you think, then the court's not going to be satisfied with just the other 3 telling the judge that. The court's going to want due diligence. The court is going to want people to hire a private investigator, hire a genealogy company, publish in a local newspaper to put them on notice that this is happening, okay? There's going to be, as I'm sharing, costs and fees. There's going to be a complete lack of privacies, okay? Privacy. There are, the probate proceeding is completely public. You file the probate petition in the surrogates court, in Jamaica, Queens, or Nassau, or Mineola, or Riverhead. And there are literally companies that are in those clerk's offices harvesting that data. Addresses, children's names, assets. Why put that out there? In this day and age, keep things private. Stay out of the courts, all right? Stay out of probate. Your distributees, as the court calls them, the law calls them that. A distributee is your next of kin. That's your heirs. As I was just sharing, if you have 4 children and there's one missing, you got to locate them. I'll give you another example that unfortunately happens. If you have 4 children, but one is not involved, one is disinherited pursuant to the plan, in a probate proceeding, if we have to probate that last will and testament, do you think that 4th child is going to come to the court and say everything is fine? No. The part people don't realize is the law requires that all distributees, all of the children, whether you're inheriting or not, have to sign off on the proceeding. If there is a distributee with a disability, the court is going to appoint a guardian over that, a guardian ad litem for a short period of time, over that beneficiary to make sure they're protected during the proceeding. So if you have a disinherited child, or an unlocatable child, or a child that has disabilities, then all the more reason to set up your plan to pass on to your children privately, okay? do the right thing, but just stay out of the courts. Okay. That's just going to increase the delays. We have some estates 2-3 years at this point, just because we're dealing with genealogy companies in Europe. Okay. That's what the courts require. It can get very complicated. Also, real estate. So what the law says is that if you have your house in your name here in New York, but let's say you also have a piece of land, a cabin in Pennsylvania, your name alone, you pass away, probate in New York and probate in Pennsylvania. Wherever you have real estate, there must be some type of probate proceeding. It can be what's called an ancillary proceeding, or it can be a second proceeding. You can avoid that, okay, by avoiding probate, okay? Court backlog and closure. This was big last year, and gratefully they seem to have caught up. But what if it happens again? With the pandemic and the shutdown, the courts were closed just like every business out there. And then when they started opening up again, could you imagine the backlog? Well, it existed for months, and we might be on a year at this point of backlog. So the concern is, if you're going to the courts, you lose control of timing and process, right? I mentioned briefly before Medicaid. If your parent is on Medicaid, living in their home, and they own that home, it is true that Medicaid law says Medicaid won't touch that house while the Medicaid recipient or spouse is living there. That's good, but you shouldn't have the house in the parent's name at all, because when that parent passes on or vacates, perhaps for assisted living or nursing home, if nobody else is living there that qualifies as an exempt person, Medicaid's putting a lien on that property. Not only that, if the parent passes away owning that house, Medicaid estate recovery becomes the issue. That's where Medicaid goes after the estate. They place the lien, they place a claim against the estate to get paid back. If there's no probate proceeding or no administration proceeding, by the way, administration is when there's no will in place. Probate is when you have a last will and testament. Administration is when there's no last will and testament. So Medicaid's coming after the estate. So why not do all that you can to avoid that? All right, do the planning and the protection so that we can save that asset from Medicaid going after it. Also, I've got Medicaid right of election there. That's another risk when it comes to Medicaid. If we have a husband and a wife, and the husband's on Medicaid, but the wife passes away first, that wife is going to have a plan, probably leaving the assets to the children, because if that wife has a will leaving her assets to the husband, but she dies first, now probate's going to require the assets going to him. You can see the problem there, because Medicaid has those asset requirements, right? So an intentional plan is that the wife's assets will drop down to the children. New York has a law that says that Medicaid recipient spouse can actually go after a piece of the estate. It's what's called a right of election. So that Medicaid recipient spouse may not do it themselves, but Medicaid can stand in their shoes and do it on their behalf, go after the predeceased spouse's estate and collect 1/3. Okay. So there are a lot of significant risks when we're talking about probate, and we're talking about planning. Most of all these can be completely avoided. All right. So you just got to take the time to do the planning and the protection before the crisis occurs. Okay. So those are the three main risks that we're talking about. So what are the options to protect? Well, it all depends on your timing. You can plan in advance, or you can be stuck in a crisis. I share this as often as I can. If it is a crisis situation, meaning that all of the planning and protection wasn't done beforehand, before the look back period, if you will, before the person passes away, before the capacity is lost, you're going to find yourself in a crisis. And a crisis is, you just don't want to be there. But a crisis is going to always be more stressful. A crisis is always going to cost the family more. A crisis is always going to leave you with less options. So by planning in advance, the opposite should 100% be true. You'll have options. You'll be able to choose what you're going to pay, because you have the ability to make the decision. You have the time to make those decisions. And because you're in control of the process, it's less stressful. So advanced planning, 100% all the time, better way to go. And that's what we do for families. But a lot of us perhaps are getting stricken with a crisis that was completely unplanned, that we can't do anything about. So then we deal with the crisis plan. But with all due respect, if you're hearing my voice and you are over 65 years of age, or your parents, loved ones are over 65 years of age, you should have a protection plan in place in advance so that you can avoid or minimize these risks and the crisis later. Okay. So what are the options to protect? Well, we have trusts, which we'll talk about. There's gifting of assets that we'll talk about. The idea of a life estate, we'll talk about a little bit. Power of attorney, that is an option. That gives your agent the ability to plan and protect for you. Those green items are all those that you can do in advance, okay? Some of them we could do in a crisis as well, but they'll be a part of an advance plan. And then we've got our big red one. If it's a crisis, and if we're talking about Medicaid in a nursing home or Medicaid in the home, once that new look back kicks in, we might be talking about this promissory note strategy. You don't want to do this if you don't have to. The promissory note strategy is a crisis plan to shelter some of your assets. The green here, those are strategies to protect all of your assets. All right, so you see the difference? Advanced planning usually means we can protect as much as possible. All right, it's hard to protect everything, but we can protect as much as we can. In the promissory note crisis scenario, we're going to be limited, all right, because we didn't take advantage of time and strategies that are the green ones here, okay? So let's talk about trusts. A trust is nothing more than a written agreement, okay? And I'll talk about the parties briefly in just a moment, but it's a written agreement that says, I'm giving certain assets to a person called a trustee to manage for me while I'm alive and healthy. And that agreement's then going to say that trustee will manage my assets if I'm alive and not so healthy, needing care and so forth. And then ultimately that written agreement is going to say, when I'm gone, this is where the property goes. This is where the assets go, like a will, but without the courts, without probate. Okay. So a trust it's simply a written agreement kind of detailing that kind of management and use of the assets owned by the trust. Okay. Every trust has to have certain parties, has to have 4 things. You have to have a grantor. That's typically the parents. That's the creator of the trust, the one granting it. You have to have a trustee. That's the manager. Most of the trusts that we work on are what are called irrevocable asset protection trusts, or sometimes called irrevocable Medicaid trusts. And I'll, again, get into that briefly in a moment. But in that case, the trustee is not the parent themselves. The trustee is going to be the child, all right, a trusted child or 2. Every trust also has to have a beneficiary. In that irrevocable type of protection trust, the beneficiaries are broken up. You know, the parents are beneficiaries of a certain portion of really the income. But the principal, what's inside the trust, the children are the beneficiaries of that, all right? That's the purpose of that type of trust. Retain income for yourself and make sure that the assets are there for the kids, okay? And again, I'll get into those details a bit. Then the 4th requirement for a trust is you have to have assets. You have to have the house, or you have to have money that goes into the trust. Something has to be managed by it, okay? Now, there's 2 types of trusts. You've got revocable trusts and you've got irrevocable trusts. I was just speaking briefly about the irrevocable. The irrevocable is meant to be about asset protection. The revocable trust is meant to be about probate avoidance. It's about control and access. With a revocable trust, the grantor creator is also the trustee. He's also the 100% beneficiary. Full control, full access, okay? Therefore, no protection. The irrevocable trust, as I was talking about, the grantor parent is the creator, but the child is the trustee. And the beneficiaries are split between the parents and the kids, therefore limiting control and access. Therefore, we get the protection, okay? So look at it this way. There's, again, 2 main trusts, revocable and irrevocable. 2 main purposes, okay? The first one is avoiding probate. The second one is what we've been talking about, which is asset protection. Anything owned by a valid trust will avoid probate. I said that a few minutes ago when we were talking about probate, right? I said jointly owned beneficiary accounts or those in trusts. If your house is in a trust, it will avoid probate. If your financial account is in a trust, it will avoid probate. Some clients come to us with just the goal of avoiding probate. If we're sitting with a client with a significant net worth, we're not so worried about asset protection in Medicaid because perhaps they have the insurance or perhaps they're going to pay for the care themselves. In that case, really, probate avoidance and planning is the entire goal. So the revocable trust 100% avoids probate. Irrevocable trust, again, you know this, it avoids probate because the assets are owned by the trust. Now, on the protection side, like I shared, in the irrevocable, different access and control for the purposes of asset protection. Now, because the revocable trust, the grantor, the client, you have full access, full control, no asset protection whatsoever, okay? Only the probate avoidance, all right? And it can also help with the guardianship stuff too, but no asset protection from Medicaid, right? So let's talk a little bit more about the irrevocable asset protection trust. Again, it's a main staple of what we do. I've done these trusts for my own family. We've done hundreds and hundreds of them. I think this January is going to be my 24th year of practicing elder law and elder care law. And we've done, it's got to be over 1,000 trusts in helping families. So this is a very, very common and useful tool, okay? As long as it's done at the right time. So that Medicaid look-back period, right? You're doing an irrevocable asset protection trust because you're thinking about the future and you're preparing for care down the road, and you're saying, how can I protect this asset so it's available for my spouse, or how do I protect this asset so it's available for my kids when I'm gone? The look-back period, the 5 years and the potential 2.5 years, 30 months for home care, the 5 years is out there now. The 30 months for home care will be out there next year. What we tell people 65 and above is get your planning done, get your protection done. It's 2021, get it done, go live your life. 5 years, go on vacation, take care of the grandkids, go to Disney, live your life. 5 years later, it's all done. The look back period is over. You no longer have to worry about protecting the assets that are in the trust, okay? Next point. This is the most significant aspect of the irrevocable asset protection trust. It's the most important rule. It's what we call the no principal rule. And what this says is whatever's inside that trust, right? The irrevocable. Remember I said access and control. Whatever's inside that trust, the grantor, the parent, no longer has the ability to access that trust principal. This is how we again get the protection. The concept is this. If I create an irrevocable trust where my dad, as the grantor, has the ability to go in and take money out, or if I, as the trustee, have the ability to write him a check for the principal, if he has access, then so does Medicaid, all right? So the underlying point, as I mentioned before, is access and control. If my dad has the ability to pull 100 grand out of a trust, then so does Medicaid. So we have to build a wall between my dad and that money. And this rule is that wall, okay? Now, because of that rule, as I tell every single client I talk to about this, you always leave enough money outside the trust to live off of. In addition, we always build in a backdoor. So there's a provision for children to receive principal, okay? So if you want to know more about this, we can have a Zoom, we can meet one-on-one to talk about it, or you can catch one of our prior webinars where we talk about this with a little more depth, okay? These trusts are built so that income can be distributed out to the grantors. 100%, there will be the right to live in that house, meaning your kids can't kick you out of it. Real estate taxes will remain the same. You don't lose your exemptions. Veterans, senior citizens, STAR, you keep the exemptions. 100% have the ability to sell the property from the trust through the trustee and buy another property, okay? All seamless. If you sell it in 3 years, you don't restart the look back, and you certainly don't have to do a new trust as long as it's all done properly. Trustee and beneficiaries. The grantor parent controls the trustee, meaning they can fire them, okay? Very important part. The clients usually laugh at that part, or elbow the kid. Beneficiaries, the child, forgive me, the parent, the grantor, has the ability to change the beneficiaries. So even though it's an irrevocable trust, and you're locking these assets up to protect them for the family, if you name your 3 children as beneficiaries, you still have the ability to change them. You can remove a child if they've done the wrong thing. You can bring the grandchildren in if you want. A lot of flexibility there. Sorry. Excuse me. Good old Apple Watch. Taxes. The way I share about this trust is these trusts are tax neutral. Your real estate taxes don't increase. Your income taxes don't increase because you're getting the income. And capital gains taxes, as long as the trust is drafted properly, the capital gains taxes, the $250,000 exclusion per owner when you sell, or what's called the step up when the person passes on, those capital gains benefits remain with this type of a trust. So your taxes don't go up because of this trust. Your taxes don't go down because of this trust, okay? And ultimately, it's important to realize that even though it's an irrevocable asset protection trust, if it is necessary, and if everybody involved agrees, the trust can be revoked. I have only had to do this a handful of times throughout the years, but for those folks that really want that level of control, knowing that if everybody agrees, that's the parents, that's the trustee, that's the beneficiaries, then this trust can be revoked in its entirety, okay? Very, very important asset protection tool, again, used every day of the week by elder law attorneys and planning attorneys that know what they're doing. Now, I've had some clients say to me, why don't I just give all the cash and the house to the kids, right? Why don't we do that life estate scenario that I mentioned earlier? Well, it's because of the Ds, okay? The Ds are the reasons and the risks of putting your children on your assets directly. I'm not talking about naming them as trustee, because if you name a child as a trustee, that's a fiduciary role, like it's an employee, so to speak. But if you give 100 grand to the child, or you give your house to the child, these are the risks you got to worry about. If that child dies before you, where does it go? Where does your money go? If that child becomes ill or suffers from a disease, what happens to that money? Do they need Medicaid themselves? Do they give it to somebody else? And now you're losing even more control. What if that child is divorced or goes through a divorce? What if that child unfortunately has a drug issue or another addiction or incarceration coming up? What if there's financial problems and debt? What if they just do something dumb or dishonest? I know it's another D, but it works. You know what I mean? Because sometimes people do dumb things and you don't want them doing dumb things with your money. And now I'm stretching it, I know, with the Ds, but what if you give the assets to the children? You're going to deal with increased taxes or a duty, right? The capital gains taxes, the real estate taxes. If you give the house to the child outright, there goes your tax exemptions. There goes your capital gains concerns, all right, out the window. So you always have to be careful how you structure the transfer and the asset protection, all right, because you got to be careful of these Ds. Power of attorney. Can't overemphasize how important this is. And I know I'm running a little over today, so I'm going to keep moving. Power of attorney is, like I was talking about in the guardianship process, this is how you avoid guardianship. This is where you can appoint somebody to handle your legal and financial affairs. New York State just changed the form back in July, okay? So if you have a power of attorney prior to July, it should still be valid, but you should get it looked at. You want to make sure it's durable. You want to make sure it has the right modifications, okay? The form that the New York State Legislature created, the form that you get on LegalZoom or the form you get at Staples, doesn't have modifications built into it. That's why you go to somebody like us. We'll build in the asset protection or the income protection provisions. We'll deal with the Medicaid and the retirement accounts and the taxation. That's the purpose of modifications, okay? It 100% has to be executed properly. If it's not, just put it in the trash, okay? You want to pick the right agent, typically a spouse first, if that's appropriate, or then a child. You can have more than one agent. You can have them act separately, or you can require them to act together. And if it's done correctly, it'll avoid the guardianship that I mentioned earlier. So again, I mentioned your options and the timing of this. You can do things in advance. That's why we're here, to help those families prepare for this down the road. But the crisis can also occur. And guess what? That's why we're here also. We've helped many, many families through the crisis scenario. And that, honestly, on the care side, that's how it happens a lot of the time. All right. As I shared, the crisis hits. Let's say, for example, mom has the house, mom's got $300,000 in her name, and all of a sudden she needs care. She fell one more time than expected. There was a stroke, there was something else. She needs hospitalization, she needs rehab. The doctors are saying she can't be home alone. God forbid the doctors are saying that she requires 24-hour care in a facility. Those things happen. We don't want to think about them. We don't like to think about them. So planning for them will help minimize the risks should they occur. All right. Now, in the world of asset protection, if there is a crisis, we can, as I shared before in the red lettering, utilize what's called a promissory note. This is how we can shelter assets in a crisis with a nursing home. Okay. However, before we get to that promissory note strategy, the Medicaid rules do allow for certain what are called exempt transfers. That means if I have mom and dad needs care, all of the assets can go to the spouse, regardless of the look back, regardless of any penalty calculations. Transfers between spouses are always exempt, okay? Transfers to a disabled child or a trust for a disabled child, also an exempt way in a crisis to protect the assets, okay? There's also something called a sole benefit trust for a disabled child under 65. Again, it's another exempt way in a crisis. If you're doing the irrevocable asset protection trust in advance, you're not going to have to rely on these alone, okay? The house itself, the house will be exempt if the spouse is living there while the spouse is living there. As I shared earlier, spouse is gone. If the other parent vacates or passes, you have to worry about that Medicaid estate recovery, right? So the house going to the spouse is used in a crisis only. There's what's called a sibling with an equity interest. We've had this. Two sisters own the house together, or one owns it, but the other one's lived there for decades and helped. That house will also be exempt during that other sister's life, okay? There's something called a caregiver child exception. That is a great option and used actually pretty frequently. That's where we have a parent going into a nursing home, but a child has been living there for at least the 2 years before the parent goes into the nursing home. That will be an exempt transfer to that child. Okay. Again, it's an option in a crisis. Okay. Not something you want to rely on because the trust would be a little more flexible and have more options for you. But if we don't have any of these exempt transfers, then we start looking at the promissory note. And that is the crisis asset protection strategy where we can save only between 40 and 60% of the assets. It is an asset protection strategy, but it's a crisis strategy, all right? Not something you should rely on. This is for families that didn't protect at all prior to the crisis struck, or they didn't protect enough before the crisis struck, or we don't have one of those exempt transfers as an option, okay? So I went a little bit over. I threw a lot at you today. If you have questions, I'll be happy to answer them. If you want to talk to me more about it personally, call the office, all right? Last point, when should I protect my assets? If you didn't get it, you got to protect them as soon as possible. And the reality is that we can talk about this in person through a consultation in person or in the office. Now, the way we do this is what we call an elder care protection plan, okay? That's the irrevocable trust plan. That's going to be where we're implementing the proper last will and testament, the durable modified power of attorney, the healthcare proxy, the living will, and ultimately the irrevocable trust to protect the assets, okay? So the elder care protection plan, that's what we're doing for folks 65 and above, all right? If there's health issues, we're doing it for those people under 65. But that's the plan that will help you prepare for the care later, give you the most options and the most protection down the road. So again, if you have questions, you can email me directly. You can put a question in the chat box. Let's see if we have any questions, folks. Anything at all. I'll be happy to answer them, even though we're running out of time. All right, I don't see any questions there, so I'm going to say thank you for joining me once again. We're here to help, all right? Just reach out and we'll do all that we can for you. Thank you very much. All right, bye.